Hello everyone, welcome to Legal Darshan. In this video, we are going to look at Gujarat Urja Vikas Nigam Limited versus EMCO Limited and others, which is numbered as 38 in the list of AOR leading cases. Now, this case, the head notes that are given for the AOR exam in the PDF shared on the website, Supreme Court website, it basically pertained to the change in tariff. Okay, so when the tariff plan is changed, how does it have an impact on the income tax? That is what the head note herein is dealing with. Okay, so now basically what happens herein that the petitioner and the that the appellant and the respondent, okay, I'm so sorry, the appellant and the respondent, they come in an agreement. Okay, they come in a power purchase agreement, which is called PPA, and for the development of a thermal power plant. Okay, now this electricity units were to be supplied by EMCO to Gujarat Urja Vikas Limited, and they mentioned a specific tariff. Okay, now a specific tariff is mentioned to them. So basically what happens, we have to we need to discuss it with section 32 of the Income Tax Act, which is providing some kind of tax subsidies. Now basically what happens is that EMCO Power Limited, they tried to contest that coal supplies, and due to some coal supplies and operational issues, they had financial hardships, and they revised the tariff. Okay, so one tariff was given earlier and another tariff was given few days later because the agreement could not be completed within the stipulated time. Okay, now what is happening in this case is that we are looking at, okay, so we are looking at yes, the benefit of accelerated promotion, which flows from the Income Tax Act. Now what happens is that the tariff is being changed, and the Gujarat Urja Vikas Nigam Limited, it is challenging the change in tariff because the case goes before appellate forum for electricity tribunal. The case also goes, and then the appeal lies in the Supreme Court, where the Gujarat Urja Limited is challenging the tariff changed by the EMCO. Now EMCO is saying here in that it faced financial hardship, so it increased the tariff amount, whereas Gujarat Urja Limited herein is saying that EMCO is already compensated through tax benefits, okay, which included accelerated depreciation under Section 32 of the Income Tax Act. So when EMCO has claimed tax benefits under Section 32 of the Income Tax Act, that subsidy, that tax benefits have been claimed using also including accelerated depreciation, then how is it putting forward the claim of financial hardship and revision of the tariff? Now, court is basically emphasizing that EMCO has entered into the power purchase agreement with full knowledge, fully equipped with the cost structure, what will be the electricity supplies, what will be the raw supplies, what are the available tax benefits, which included the benefit provided of depreciation under Section 32, and tariff bid was fixed. The bidder had the opportunity to factor in tax benefits like depreciation at the time of bid, but later when the EMCO, it is claiming financial difficulty without acknowledging the tax benefits availed, is not a fair justification for changing the tariff plans. Okay, so EMCO cannot selectively highlight losses while it ignores the gain it achieved through fiscal statute, which is the income tax here. So now court is basically saying that respondents herein, they know that they will get tax depreciation benefits, and that particular on some particular amount, and now they quote that amount, and unless there is a real change in law. Okay, so if there is a change in law, some taxation based change, some fiscal based change in law by the law passed by the parliament, changes might happen, but tariffs once decided in bidding, they cannot be revisited, and they cannot be revised just by having just in the pretext of financial losses. Now basically court is saying that contractual sanctity is to be respected and commercial risk allocation has to be kept in mind here. Now, if EMCO is allowed to claim losses here and the revised tariff plan is applied, it is basically a narrow escape from the contract terms after it has availed the tax depreciation benefits under Section 32 of the Income Tax Act. Okay. Now, court is saying herein that it would amount to having your cake and eating it on your own too, and this cannot be allowed. Okay, so now this is what mainly the head note of this judgment contains, that contractual sanctity has to be preserved, and EMCO, when it sought to revise the tariff plan, it is not a change in law, but it is merely a contractual change that it is happening on the financial convenience of the EMCO Limited. So the court is allowing this appeal. Court is saying that the change in law must be statutory and it cannot be based on a commercial contract or cannot be merely administrative in nature. When EMCO knew the risk calculations of the supplies, when it entered into the power purchase agreement, now making a claim that there is shortage of material and there is cost increase, it will not automatically qualify the EMCO to revise the tariff plan, even if the agreement has not been completed into the stipulated time. Okay, now the PPA, the power purchase agreement, herein is a binding agreement, and the tariff was fixed because it was gained through the bidding. And power producers cannot shift risk back to the purchaser unless there is a legislative act allowing it. Now, court is also holding that once the benefits are availed under Section 32 of the Income Tax Act, you cannot enjoy tax advantage like accelerated depreciation and then later claim tariff revision, claiming that there is a financial hardship. Okay, now this is it, which was held in the judgment of Gujarat Urja Vikas Nigam Limited versus EMCO. And I hope the discussion is useful. This is what is written in the 3 pages of the head notes as given by the website, as given on the website. Okay, so this case basically deals with the sanctity of contract, some electricity law provisions, and also the fiscal provisions which are contained in the Income Tax Act of India. All right, so this is it for the judgment. It's an easy read. You may read it together with this video. You can just go through the judgment head notes that are given by the AOR website. I hope the discussion would be useful for you. Thank you for watching. Please stay tuned with us on Legal Darshan. Have a great